Thank you. And our next question, Mr. Faulkner.
This is for the 264 candidates. Do you feel that it takes too long to get a felony case to trial? And if so, what would you propose as solutions to shortening that time?
And we'll start with Paul Leapak and go down in order, and then the next time there's a question, we'll go in reverse order.
Thank you. In general, I would say the answer to that question is no, that I don't think it takes too long to get a felony case to trial. I do think you have to, there's obviously two different sets of circumstances when you're looking at trial preparation. One is when the defendant is in custody, and the other is when the defendant is on bond. Both of them have concerns with delay. One is a cost for the defendant who's in custody, and one is the need to have the defendant appear if he's on bond. And the longer the case drags, the more cost you have and more potential you have for a defendant not to be present. But no, in general, I think our cases move at an appreciably rapid pace. The discovery process and the changes we've had in felony discovery have created, it seems to me that a lot of times when a case comes up early, pre-trials, all of the discovery process has not been worked through. So it feels to me like many cases require more than one pre-trial setting and a little bit longer before they even get put on the trial docket. But for the most part, I think that compared to other counties, Bell County moves at a reasonable rate. Do you have to keep an eye on it? I certainly think you have to keep an eye on it. But I don't believe we have a significant problem with trial delay.
Mr. Deskey?
Thank you. I'd echo a lot of what Paul just said. It's hard to say that cases aren't moving fast enough because every case is different, and cases can move fast when they're not as difficult a case or there's not as much evidence that has to be provided to the defense. Paul indicated that the discovery process has changed here. It certainly has ever since the Michael Morton Act was implemented. You've seen defense attorneys get much more discovery in the pretrial phase, earlier in the case. Sometimes it does cause some what appear to be early delays in how the case moves forward, but it also lets us get this case completed with a good knowledge of what the case holds and what we can do in those cases. I think the cases are moving fine. Again, each case is different, so it's hard to sit here and say that they're not moving fast enough or they're moving too slowly, and just have to leave it at that.
Mr. Parker? I have to switch on my list, but I'll...
All right, well, good. I'll give Randy a heads up because I'm going to disagree with the first two. How do we know if we're moving cases fast enough? Well, let's look at state averages. In Bell County, a third of our cases are resolved in less than 30 days. Statewide, it's about half. Okay, maybe we just don't get them done as quickly. Well, let's look at over a year. A quarter of our cases in Bell County take more than a year, felony criminal cases. Statewide, it's 10%. So yes, are cases moving too slow? Objectively, we can look at the data and say, yes, compared to the average county across the state of Texas, we are moving too slowly. Now, are there solutions? The question is, what are the solutions? Yes, you have to stay on the defense lawyers, you have to stay on the prosecutors, and you have to make sure everybody's doing what they're supposed to be doing. The judge has to remain neutral. The judge doesn't pick sides, but the judge controls the pace of litigation, and it's a judge's duty to make sure that's done. We can do it elsewhere across the state of Texas. There's no reason we can't do it here. My experience in being a board-certified criminal defense attorney, trying everything from speeding tickets to death penalty cases in this very courtroom, I have the experience to tell you how a case is supposed to be done, what the timeline should be. I've been a prosecutor, I've been a defense attorney, I understand it from both sides, and I know the troubles that affect both of them and the reasons for delay, and when somebody's being sincere and when somebody's just playing the system. So yes, there is a system and there is something that can be done about it.
Randy Dale.
Well, I'm going to try to strike a happy balance between both ends. The proper administration of justice in especially felony cases, you cannot put a timeline on that because there are so many things outside the control of the prosecutors and the defense lawyers. Because quite frankly, our cases are only as good as the case as it comes in from the law enforcement agency. And if you've got a case where you've got a busload of eyewitnesses and a confession, well, that case is going to move on a whole lot faster than if you've got a case where you've got wiretap evidence and DNA evidence and blood evidence and these things where you involve medical people and scientific laboratory experts. And you just cannot put a timeline on the administration of justice. And all the guys have said, every case is different. They are. Every defendant is different. Every prosecutor's office is different in the way to approach it. But certainly, Jeff is right in that the judge can be the referee. The referee is not going to call the plays. He's not going to make any tackles. But he is the one that can say, hey, at 7:30 we're going to kick off, and when the clock reads 3 zeros, we're done. The judge can do that, and he can hold people to the fire. A scheduling order is used in a lot of counties to keep those cases on track. But when you're talking about someone's, especially felonies, where you're talking about someone's liberty, a number of years in prison, possibly the death penalty, you've got to proceed deliberately and carefully. And if that means it takes a little longer, that means it takes a little longer. But certainly with the best interest of justice in mind, you proceed with all the impacts.